Dear students, we know presently the mains examination is going on for the year 2025. But however, the GS papers are all completed. So this session is basically, I wanted to share some of the insights based on my experience in UPSC as to how this year the GS paper 2 has been asked. And that too, especially, we are going to see the discussion for the subject polity in GS paper 2. Now, if you see the analysis, first we'll try to understand the weightage for GS paper 2, the weightage for the different subjects in GS paper 2, and then we'll try to see that how this year paper is little different from the other years, if at all any differences are there. Then we'll also see how UPSC is focusing upon. Is they following a particular trend? Is there any shift in the trends in this particular year? And of course, then we'll go to the discussion of some of the questions, a very quick discussion so that the students can have an idea on this. So if you see overall, you know that every year UPSC asks 20 questions in all the GS papers, especially in GS paper 1, paper 2 and paper 3. So this year also the same trend. And in GS paper 2, if you see, there are 4 major areas. One is polity, governance, social justice and the IR part. So here this year, if you could see, 50% of the marks are from polity. Not only 50% of the marks, 50% of the questions as well. Out of 20 questions, 10 questions are from polity. And the marks, the corresponding marks, if you see, it is for 125 marks. And remaining 125 marks is for all the other areas. That is why I keep telling the students, so polity is the major area where the questions are likely to come. And if you see further in that, there are 5 questions of 10 markers and 5 questions of 15 markers. So overall, it is 125 marks. And then further breakup, if you see, 50 marks for the IR part, which is more or less standard, and 75 marks clubbed together for the governance and the social justice area. So one major shift I could see is this year a little bit more weightage has been given to polity. So normally it comes around 110 marks or 100 marks, but this year exactly 125 marks for the subject polity, which I think is likely to continue. Even if it changes also, not less than 100 marks are going to come from the subject polity. So polity forms a very, very important area. But to score well, students should also focus on the other areas like social justice and governance in addition to IR, so that your marks can increase up to 125 or probably you can cross that also. All right. Now, if you see the questions, how the questions has been asked. So again, if you see the first impression for me is UPSC has always been doing this. They are trying to spread the question across the different topics that is given in UPSC syllabus. Those who want to score well, the simple thing that you have to do is whether your preparation is covering every topic that is given in the syllabus. So here also, if you see, these 10 questions are spread across different topics. And to me, this year, if the students are prepared on the topics and little bit updates on the current affairs, still they are in a position to do it well. So it is very important first you stick to the basics. The basics is whether you are covering something in the syllabus, thematic based questions. From different themes, the questions have come. So as we'll proceed, we'll try to understand. So for example, as a repetition, this year also there's a question in Representation of People's Act, which is there in the syllabus. Comparison of constitution across the world. There are questions from statutory bodies, constitutional bodies. There are questions from topics like judiciary. So which is normally what UPSC does, but this year I could see that there are a few areas where the UPSC has not asked the question. So that is little unconventional to me. For example, there are no questions from the topic of legislature. There is no direct question, at least from legislature. Legislature is seen as one of the important areas. So UPSC can change suddenly the direction as well. I also see not direct question from the topic of what is called as executive as well. Of course, there is one question from Attorney General. But again, that can be related to 2 topics in the syllabus. One is executive and other is what is called as constitutional bodies, because Attorney General itself is a constitutional office. So this year I could see one trend is there is a lot of overlap between certain topics. Say for example, executives and constitutional bodies, judiciary and comparison of constitution across the world, again executive and comparison of constitution across the world. So this year at least I could see 2 questions which is overlapping with other areas with that of the comparison of constitution across the world. So in the way, students should also have developed this ability of interlinking the topics. So therefore, they can do well when it comes to the examination. But otherwise, my observation, students who have done the basics, they will be able to do easily at least 80% of the questions. That means out of 125 marks, I'm sure that students will be able to do 100 marks very easily. One or two questions might be little difficult, not the entire question, part of those questions might be little difficult. And as we'll proceed, we'll also see that many of these questions has also been covered in some of our classroom programs, mostly in our foundation program as well as in our mains masters program. Anyways, we'll just go to the questions and see those questions. So come to the first question. I'm going to do only the polity questions in this particular session. Okay. So come to the first question. Discuss the corrupt practices for the purpose of Representation of Peoples Act 1951. Analyze whether the increase in the assets of the legislators and or their associates disproportionate to the known sources of income would constitute undue influence and consequently a corrupt practice. So if you see, this question is directly picked from the topic of RPA, Representation of People Act 1951, which we do regularly cover. And in fact, I keep telling the students that there is definitely going to be a question from Representation of People Act, and that too from what is called as disqualification of the members of the parliament and the members of the state legislature. And within disqualification, I do give a lot of emphasis on what is called as the corrupt practices. So the question have come from corrupt practices, but it is only the part of the question. So if you see, this question wanted you to give an idea as to what are all the corrupt practices under the Representation of People Act. So what are corrupt practices? So basically, someone engages in bribery during the election, or someone who does undue influence. Undue influence means any kind of action that would affect the free and fair elections, use of coercive force and all those things. And then misuse of government machinery for the purpose of elections. So broadly, these are all considered to be what is called as the corrupt practices. But the question does not stop here. The question is further asking, analyze the increase in the assets of legislators or other associates disproportionate to the known sources of income would constitute undue influence. So you should also know whether if any person who is an MP or an MLA or who wanted to contest election, if they have assets disproportionate to the known sources of income, can that be considered to be an undue influence? Presently, that is not covered within the definition of undue influence under the Representation of People Act, because the Representation of People Act, section 123, to be very specific, 123 class 2 talks about what is called as the corrupt practices. So undue influence is part of corrupt practices, but however, disproportionate asset is not covered legally within what is called as undue influence. Although disproportionate asset could be a criminal offense under the Prevention of Corruption Act 1988, but that is not covered under what is called as the corrupt practices under the Representation of People Act. So that is what you'll have to explain it here. So it's basically a combination of Representation of People Act and partly that you should have an idea of what is called as the Prevention of Corruption Act as well. Anyways, these are all the things that we have covered under the governance topic as well. So yes, using both the knowledge, I think you can answer this particular question. So this is one thing that I'm seeing this year, that how questions are a little interdisciplinary, rather than I would say it is connected between different topics, not just purely from one topic. So only when you use that, you can get full knowledge, better marks for a particular question. Now, please come to the second question, which I see as a very conventional question. So this is one that we regularly do in the foundation, we regularly do in the mains master program as well. So come here, comment on the need of administrative tribunals as compared to the court system. So basically, it is comparing judicial and quasi-judicial bodies. So this I see it's a direct question from quasi-judicial bodies, which is also there in your syllabus, and judiciary, which is also there in your syllabus. Again, interlinking of these things, you'll have to compare basically. So how quasi-judicial bodies can be better than the judicial bodies? Basically, what are the advantages? Advantages can be in terms of the procedure. The procedure is very simple in quasi-judicial bodies. Advantages in terms of the fee structure. Advantage in terms of speed of the judgments. Advantages in terms of what is called as the specialization, probably the specialization in terms of jurisdiction, expertise. So these are all the areas as to why the tribunals has been brought in. But at the same time, if you see, it has its own disadvantage. For example, quasi-judicial body is not as independent as that of judiciary. Their service conditions is not as good as that of judiciary. There could be potential conflict of interest because they're under the control of the government when it comes to quasi-judicial bodies. So these could be potential disadvantages also. I think the first point is you have to bring out those things. And then the second part of the question is assess the impact of recent tribunals reforms through the rationalization of tribunals made in 2021. So in 2021, when the budget was passed, when the Finance Act was passed, a lot of reforms in the budget has been, a lot of reforms in the tribunals has been done. In fact, they're done with a lot of unwanted tribunals. They rationalized the existing tribunals. The government brought in uniformity in terms of their service conditions, tenure and all those things. And apart from that, it brought in a select committee based on which the members shall be appointed. So these are all some of the changes that has been brought in. You have to do that. And probably you can make a little bit analysis that try to improve upon the independence, that try to bring in uniformity. But at the same time, critics also say that this also enhances some element of government control over the tribunals as well. So that is what is expected, I think. So I would say the first part of the question is very, very conventional. The second part of the question is related to your current affairs, but that too not a very recent current affairs. So UPSC sometimes goes back. So it is in 2021, but however, that is the latest development that has happened for tribunals. So the idea is you should also always keep focused when you prepare a particular topic. What are the latest reforms that has been happened in a particular area? So UPSC may pick that. To me, it's a very easy question. Students who have prepared this, yes, part of the question is easy, part is it requires interlinking. Now come to the third question. So compare and contrast the president power to pardon in India and in USA. Are there any limits in both the countries? And what are preemptive pardons? A very good question. So this is directly coming from the topic of comparison of constitution across the world. And that is one thing that UPSC is asking question every year. And I do keep telling the students, mostly the questions are likely to come from only three countries, USA, UK and France. And UPSC has not gone beyond this. And this year also, again, the comparison is with USA. So it's very easy. Even if the students does not have read it directly, you just have to apply a little bit of what we have already learned to answer this particular question. So exactly, most of the students might know the pardoning powers of the president, which is there in Article 72. So it requires a brief explanation of what you know under Article 72. Article 72, it gives a power to the president to exercise pardon. He can pardon, he can commute, he can remit, he can reprieve, he can respite and all those things. You can write that. And then, but it also requires the comparison with that of USA. So you say that in USA also the president exercise such powers. It is not required for us to know the exact articles and all those things, but yes, the president of USA might exercise such power. But compare and contrast. So what is the difference? So both exercise pardoning powers, but if you see the difference, in case of India, if you see that this power is largely not an discretionary power, that the president has to use it based on the aid and advice of the Council of Ministers. And that is again because in India, the president is not a real executive. But whereas in USA, you know that the president is a real executive, that is more or less his discretionary powers. There's no advisory body per se based on which the president is bound to take this particular decision. That's very, very important difference. Now, the second important difference, though both exercise the pardoning powers, is in case of India, if you see that the president power is subject to what is called as judicial review. At least limited judicial review. That is what the judiciary has said in most of the cases. But whereas in USA, that is not subject to judicial review, it is only subject to public criticism. Or in other words, if at all the president exercises or misuses his pardoning power, is only that he may be subject to what is called as impeachment process, which a larger legislative body have to take that particular decision. That's again a major difference by the way that these powers are exercised. And the third important difference is we know that India is a quasi-federal in nature. So when it comes to India, there are in certain cases, even if the punishment is given by the executive authority of the state, the president can exercise pardoning powers. Say for example, if it is a capital punishment. In case of capital punishment, it does not matter whether it is a punishment based on the executive authority of the union or state, the president exercise pardoning powers. But whereas in USA, we also know that it is a truly federal political system. So in a truly federal political system, it is always that when it comes to the state executive authority, the president does not exercise any pardoning powers. So these are all the basic differences that you should know. Okay, so once you do that, then the answer is very clear. So even if you have not known about these things, you just have to apply your existing knowledge to arrive at these answers. Are there any limits in both the countries? Yes. What are the limits in India? In the limits in India, if you say that the president does not have the power to exercise with regard to what is called as uh, uh, the executive power of the state, except capital punishment. There, the president does not have any power to do that in case of the in case of the state laws. And then the last thing is, what are preemptive pardons? In fact, this is also very important. This preemptive pardon is also a difference between the way that the pardoning power is exercised by the president in India and that of USA. When I say preemptive pardon, these are all pardons that are given even before the punishment is given by the courts. But in India, the president does not exercise preemptive pardons. But yes, in USA, the president can exercise preemptive pardons. And there are history where the presidents of United States of America have exercised this preemptive pardons. Okay, so if you know all those things, this is a quite easy question. But yes, you'll have to apply, and especially when it comes to the comparison of constitution across the world, it is not possible for us to predict where the question can come. That's extremely difficult. But whatever you read in India, whatever you see, there are some important provisions related to judiciary, related to executives, related to the legislature. You will have to try to compare that with the major countries, especially USA, UK and France. And I'm sure that the students will be able to do at least part of the questions. So same is the case here as well. Now come to the next question. Discuss the nature of Jammu and Kashmir Legislative Assembly. After the Jammu and Kashmir Reorganization Act 2019, briefly describe the powers and functions. So this is what is very important. So discuss the nature of Jammu and Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act. So you will have to do the overall structure of the assembly after this act was passed. And also briefly describe the powers and functions of the Assembly of Union Territory of Jammu and Kashmir. This I see is a question predominantly coming from the current affairs. Although this Legislative Assembly, the act was passed way back in 2019, but we know that recently the elections have happened in Jammu and Kashmir. I think that's the reason why this particular question was asked. So I would give this to the current affairs based question. Although it is also related to the federal provisions, not exactly federal provisions because it is now more a union territory, but yes, more overlap with the current affairs. So first you should know the general guidelines. After the Jammu and Kashmir Reorganization Act, the act created two union territories. The state was converted into two union territories, that is Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. And the Union Territory of Jammu and Kashmir is to have a legislative assembly, and that legislative assembly will have certain elected members, and the legislative assembly will have a council of ministers, and the legislative assembly will have law-making powers. So all these things has to be in your answer. And in fact, if you see, as per the act, the legislative council will have council of ministers, which is not more than 10% of the size of the legislative assembly, and it will be headed by a lieutenant governor appointed by the president of India. So these are all the largest structural framework. When it comes to the powers and functions, yes, the legislative assembly will have law-making powers as well. And the legislative assembly will have law-making powers on all the areas in the state list in the Schedule 7 of the Constitution, except two areas, except what is called as police and public order. So except police and public order, they'll have the power to make laws, and then the executives can implement these things. And of course, the legislative assembly will have the power to make laws on all the items in the concurrent list in the Schedule 7 as well. So yes, legislative assembly of Jammu and Kashmir will have almost same powers out of the legislative assemblies of the state, but with certain differences. So that is what you'll have to bring it in this particular question. So if you do that, more or less this particular question is solved. So again, not a conventional question, but based on current affairs. But I would say these three things are mostly conventional questions. Now come to the next question. The Attorney General of India plays a crucial role in guiding the legal framework for the Union government and ensuring sound governance through legal counsel. Discuss the responsibilities, rights, limitations in this regard. Very conventional question, and we keep repeatedly doing this in our foundation course and the mains program as well. Now, if you see the this question requires your knowledge of Attorney General. The Attorney General is appointed under Article 76. If you know, you can write that, by the President of India. And the Attorney General is bound to perform certain constitutional duties because he is the chief legal advisor of the Government of India. So what are the functions of the Attorney General? He has to defend the Government of India in a court of law. And you can give examples. So with examples, you can, say for example, recently the Attorney General defended the Government of India in important cases like the electoral bond case and many other important cases like the Rafale case. And you can add many more recent cases also if you want. And then he is also supposed to give legal advice to the government. If need be, the Attorney General can be summoned by the government to defend the government in their actions in the Parliament. And apart from that, the Attorney General performs such other duties of legal nature and character as directed by the President of India. So these are all the functions that is to be performed by the Attorney General. So to that extent, he exercises certain rights as well. What are the rights? So that he can perform his duties. So he can be an audience in any court within the territory of India. He'll have all the privileges of the members of the Parliament when he is taking part in the proceedings in the Parliament or any of the parliamentary committees, except that they'll not have the right to vote. So these are all some of the rights and immunities that is given to the Attorney General as per the occasion. And further, there are also certain limitations. So first of all, the Attorney General should not hold a brief against the government. That means he cannot argue against the government. He cannot appear against the government. He cannot be a director in any company without the permission of the government. But however, all these things does not bar the Attorney General from having what is called as a private client, because Attorney General is not an employee of the Government of India. The Attorney General is just has a relationship with the government as if there's a relationship between what is called as a client and a counsel. So these are all the things I think you'll have to bring in. A very conventional, very easy question. Easily you can get 6 to 6.5 marks if you write all these points with some examples, of course. So this is what is required. Alright, so the remaining questions are not from polity. So we have discussed for 50 marks. We'll just move forward to the remaining questions. So come here directly to question number 11. So question number 11 is again one important topic, constitutional morality. And in fact, in the philosophical part, we do discuss about the constitutional morality. And normally we start our philosophical areas with topic like constitutional morality and of course transformative constitutions. These are all topics repeatedly is in the paper news, current news as well. And we do that in our multiple programs as well. So see, constitutional morality is the fulcrum which act as an essential check upon the high functionaries and citizens alike. So this is a statement that is given by the judiciary. In the view of the above observation of the Supreme Court, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability in India. So first of all, this question wanted you to explain the concept of what is constitutional morality in the view of the observation that is given by the Supreme Court, and how the principle of constitutional morality in application ensure balance between the principle of what is called as judicial independence and judicial accountability. So first of all, you should be in a position to explain what is constitutional morality. If you want to bring in case laws also, you can bring in, because in certain cases, the Supreme Court openly came and explained and applied this concept of what is called as constitutional morality. So constitutional morality is basically an idea that all institutions in our country and the citizens, they have to respect and they have to follow the values that is laid down in the Constitution. And even if those values goes against the established norms and practices and customs in the society, so what should be given utmost importance? Constitutional values. Say for example, equality is a constitutional value, liberty is a constitutional value, rule of law is a constitutional value. So even if our customs and practices are going against these constitutional values, so respect has to be given. Adherence has to be shown to the constitutional values, and that's basically what is called as constitutional morality. And this constitutional morality is not only about all those things. If you look into the entire constitution, the constitution also talks about what is called as judicial independence. That's also basically a value in the constitution. Unless until there is judicial independence, the judiciary will not be in a position to exercise its power of judicial review against the actions of the other organs in the state, against the actions of the citizens. So for that, judicial independence is very much required. So there are some provisions that is there in the constitution, especially with regard to the removal of the judges, their service conditions, their appointment, in fact, through Collegium system. These are all part of judicial independence. So judicial independence is very much embedded within the idea of what is called as constitutional morality. But however, that doesn't mean judicial independence allows the judiciary to exercise actions in such a way that they are not accountable to the other organs of the state. In fact, if you see the very idea of the Indian constitution, it believes in not what is called as sovereign authority to any particular organ, but rather it believes in the idea of what is called as constitutional supremacy. It is a constitution that is supreme, and that supremacy itself is part of the values in the constitution. Therefore, judiciary, though it should function independently, no doubt, it doesn't mean that judiciary is not accountable. The judiciary is also accountable for its actions. And that is what you'll have to bring in. And what are the ways by which we can bring in judicial accountability you can give? So already we have brought in an act what is called as Judicial Accountability Act. And then there are a number of provisions today that is there to ensure accountability. One such process is the removal of the judges. So I think you'll have to bring out all those things. So constitutional morality doesn't mean that it is giving a high position to judiciary. Constitutional morality only means that it has to protect the values in the constitution, so it will protect the judicial independence as well. But at the same time, the judiciary is not above the constitution of India. It has to function within the framework that is set by the constitution, and that is all what you'll have to bring in this particular question. All right, so if you want, you can bring some case studies also, like there are certain cases related to decriminalization of section 377, Shabrimala temple case, decriminalization of section 497. So these are all some cases where you can bring in related to constitutional morality. Very good question, and we have repeatedly discussed. We have discussed topics like constitutional morality. We have discussed questions like judicial independence, judicial accountability. But however, I would say that this question is not again only from a particular topic. It's a combination of two topics, in fact. One is the philosophical part in the constitution, and other is judiciary. So you'll have to combine these two areas to write a good answer. So that's why it is a 15 marker. So it requires a lot of application and combination to answer this question. Come to the next question. I would say this is one of the very easy question, provided the students understand. So this question is from two important topics. One is constitutional amendment and basic structure. The Indian constitution has conferred amending powers on the ordinary legislative institution, that is on the judiciary, with a few procedural hurdles. In the view of the statement, examine the procedural and substantive limitations on the amending power of the parliament to change the constitution. Very simple. So you should know what are the limitations upon the powers of the parliament to amend the constitution. But the question itself is giving a hint that these limitations are of two directions. One is substantive limitations, other is procedural limitations. So definitely you'll have to bring out Article 368, which does give the power to the parliament to amend the constitution. And if you see Article 368, it does provide a lot of what is called as procedural limitations. So what do you mean by procedural limitations? It does say that it requires certain type of majority, it requires special majority in certain cases. So that's a procedural limitation. It requires not only special majority, it requires ratification behalf of the state legislatures. In case if the amendment is trying to make changes to some of the federal provisions in the constitution, then it requires assent of the president. So these are all some of the procedural limitations that you have to brought in. That's our process. These are all procedural limitations. But however, there's also substantive limitation. What is substantive limitation? Substantive limitation means that in essence, you will not be able to change certain things. Even if the procedure is followed, still you will not be able to change it. So what are those substantive limitations? The substantive limitation is in the form of what is called as basic structure. So you'll have to explain here the basic structure, and probably you can bring out the Keshavananda Bharati case, which ruled the basic structure. You can explain basic structure, wherein it says that there are certain provisions in the constitution which forms the very basis and the founding principles on which the entire constitution is resting. So these principles never can be amended. And if the parliament is trying to change these principles which would constitute the basic structure, then to that extent the amendment can be declared to be unconstitutional. Say for example judicial independence, say for example rule of law, say for example secularism, say for example the various keywords in the preamble. These are all constituting what is called as basic structure. That's a substantive limitation. And you can say on top of that, whenever the basic structure is violated, the judiciary can exercise the power of judicial review. That is again part of substantial limitation. So you can say that procedural limitation is also there under Article 368, and through the judicial interpretation and through the doctrine of basic structure, there are substantive limitations as well. So once you bring out both the things, then you can write the answer. So very conventional, very easy question. It's just that you should know the difference between procedural and substantive limitation. Come to question number 13, discuss the evolution of Collegium system in India. Even in our foundation course, we discuss the evolution of the Collegium system through 3 judges cases. So judges case 1, 2, 1, 3. So it's very easy. You will have to just bring in the core area, only the judgments of these 3 cases. You don't have to keep explaining all the things. And then, but this question is not only about that. This is what I said, that this year there's a lot of interlinking of topics. One is Collegium system, and at the same time they wanted to compare that with the other constitution. So it is again related to the comparison of constitution across the world. Critically examine the advantages and disadvantages of Collegium system of appointment of judges of the Supreme Court in India and that of USA. So basically you should explain about the evolution of Collegium system. In addition to the evolution of Collegium system, you should also know the advantages and disadvantages of the Collegium system, and also the respective system in USA. What are their advantages and disadvantages? So once you know about the 3 judges cases, then come to the advantages. What are the advantages? The very idea of Collegium system is judicial independence in our country. And the second thing is probably that this is one way that the judiciary can preserve itself from the interference from the other organs of the state. These are all the advantages, but it does have its own criticism. What is the criticism? There's no public scrutiny. There is issues of nepotism in this. So these are all the issues that is associated with the Collegium system, completely a non-transparent affair. But on the contrary, if you see how the judges are appointed in USA, the judges are appointed in USA by the president, which is approved by the Senate. So here predominantly the role in the Collegium system is only for the judiciary. When it comes to the appointment, there the predominant role is done by the executive and the legislature. The president appoints it, the approval is given by the Senate. But the problem there is, though it brings an element of checks and balances, which does not appear to be there in the Collegium system, the problem there is appointment could be politicized. Whereas in India, the idea to have the Collegium system is to ensure the neutrality. At least theoretically, the idea is to ensure the neutrality, but there the appointments can be politicized. So yes, each and every system has got its own advantages and disadvantages. So probably you'll have to bring out those things in your answers. All right. So come to the next question. Examine the, okay, so before that, okay, so we have seen this also. Examine the evolving pattern of center-state financial relations in the context of planned development in India. How far the recent reforms impacted the fiscal federalism. So this is on an expected line. Again, every year there will be one question on federalism topic. So without any doubt, there's a question from federalism. I keep telling students, federalism, definitely there's going to be a question. So fiscal federalism has been asked. So what is a changing pattern? You just explain the overall mechanism of fiscal federalism, how the constitution does enables and protects the financial resources of the states as well. So in a federal political system, there should be division of powers. So yes, in financial division also, financial powers also, there is division. But in addition to that, how the pattern is evolving. The pattern evolving, if you see from 1950s till this point of time, predominantly the states were more dependent on the center because of the role of the planning commission. Now over a period of time, the planning commission has been done away with. Now it is replaced by Niti Aayog. And now it is not a very centralized system. That is one change. The second thing is, with the recent changes in the devolution of power, devolution of finances, especially by the 14th and 15th Finance Commission, more powers, financial powers are devolved in relation to the previous Finance Commission. That's another area. But doesn't mean that the states are happy with this. Still there is an issue because the states do have concern of increase in more cess and surcharge. The states do have a concern of the changes in the population. The states do have a concern of related to GSTs because the states feel that still they lose taxes in the form of GST reforms. But at the same time, GST Council, where the center and states both are there, so it is also seen as an example of cooperative federalism. So these are all the changing pattern that probably you'll have to bring in and write this particular answer. All right. So So this question, I would say, though it is from the federalism, it's not a very easy question, but still yes, students who got the broader idea will be in a position to approach this particular question as well. So I think we have got just one more question before we complete polity. So directly come to question number 18. The National Commission for Protection of Child Rights has to address the challenges faced by the children in a digital era, examine the existing policies and suggest measures for the commissions to initiate to tackle these issues. So this is from the topic of statutory bodies. The National Commission for Protection of Child Rights is established under the Commission of Child Rights Act. Commission for Protection of Child Rights Act. So it's a statutory body. And if you see this particular statutory body, the mandate of this particular body is to protect the constitutional and legal rights of the children. And today we have a lot of mechanisms to protect that, especially if you see the constitutional rights, we do have a lot of rights for the children. Constitutional rights like rights under Article 23 and Article 24, child labor trafficking. So similarly, the child to be protected under acts like POCSO Act, Juvenile Justice Act is there. The Information Technology Act protects any form of cyberbullying against the children. So these are all various mechanisms we do have. But however, what are the threats for the children today because of the digital era? One is violation of their privacy. It could be cyberbullying, blackmailing through using the online means, and it could also be exposure to certain inappropriate content, including pornography. So these are all the basic challenges to the children, which the National Commission for Protection of Child Rights has to evolve to protect all those things. So what are the measures that they can take? First, to bring in a comprehensive policy to deal with all the issues. Then the coordination between different authorities, law enforcement authorities, and of course certain other authorities. There should be a broader coordination. Awareness generation has to be there. A comprehensive changes in the education policy as well, because the students should be aware of all those things. The awareness drives include, especially to deal with issues of the POCSO related offences, is that today the government is also carrying out what is called as safe touch and safe touch practices. Yes, these are all the areas I think the commission has to focus more and how they can tackle these issues. And of course, yes, certain structural changes can also be suggested, that the commission should be given more finances, the appointment should not be politicized, so therefore they can take up the agenda further in protecting the rights of the children. I think this is what is relevant. So this is also a topic that we have touched upon our courses. Okay, so I would say overall this year question paper is not very difficult. Easily they can do 80 to 90% of the questions, but yes, to do most of the questions, I would say at least certain questions, like 3-4 questions, it also requires interlinkages between different topics. So that is, again, UPSC is giving us a hint that they may not ask questions from a particular topic, that they can interlink the topics as well. Most of the topics has been covered. Say, for example, questions asked from Representation of People Act, comparison of constitution across the world, quasi-judicial bodies, statutory bodies, constitutional bodies and executives and comparison of constitution across the world, judiciary and comparison of constitution across the world, and of course the philosophical topics like constitutional morality, basic structure, amending powers. So certain areas the questions have not come. For example, from historical underpinning the question has not come, which is not asked regularly. But as 2 topics where regularly questions come, one is executive and the legislature. Legislature is not even a single direct question. That is something a little unconventional. And then there's also no question from the local bodies. So otherwise the other topics has been touched. So the important thing is to do well in the examination. It's very simple that the student should cover each and every topic. All right. So if you read each and every topic, if you have content for every topic, and yes, the current updates along to that, I'm sure that 80 to 90% of the questions can be done well. So with that analysis, I'll just take a break from the discussion. In the future, maybe I'll do the analysis for the other areas as well. Thank you very much for watching this analysis of the GS Paper 2 Polity part. Meet you again in another discussion. All the very best. Thank you very much.